Alright, Cracking the Code, 3rd edition, Part 1, Section 1, Maintaining Fiscal Integrity. This is Part 4. The private agreement, contractual basis for the relationship. The document that establishes the contractual relationship between you, the living, breathing man or woman as the creditor, and the trade name, the corporately colored and legis, artificial person strawman as the debtor is called the private agreement. As a redemptor, the only requirement for forming this contract is the personal certainty that you are not the trade name and that the trade name is a bona fide legal entity separate and distinct from you. The private agreement is a bargain of the parties, in fact, and qualifies as an agreement under the code at the Uniform Commercial Code 1-102 or 3. And sample 2-page private agreement for the fictitious character John Henry Doe and his strawman, all caps John Henry Doe, is provided in the practical section and should be studied for full understanding of the nature of this particular type of creditor-debtor relationship and why such an agreement and contract is entirely legitimate. Your private agreement is just that, private, and should never be filed in the UCC filing office nor shared with any adversary. This document is strictly between you and your strawman and forms the lawful basis of your contractual relationship with each other. As a member of the sovereign constituency, the Constitution provides that no state shall pass any law impairing the obligation of contracts. Your contract with this particular person, that is ens legis, is inviolate and shall remain so unimpaired by any third party. Next section, the hold harmless and indemnity agreement. The most vital component. Despite all other incredibly positive aspects and elements of this process, if the following single point is not firmly and legally addressed and established, the whole effort can be nullified. As mentioned earlier in this essay, Big Brother's entrapment scheme consists of, number 1, corrupting a sovereign's true name into an all-capital letter citizen of the United States, quotes, trade name, and then 2, conning the sovereign into unwittingly voluntarily contracting as surety for the trade name and concealing from the victim his or her new status, but also ruthlessly enforcing the new suretyship obligations without explanation. The hold harmless and indemnity agreement is a commercial and legal document wherein the trade name debtor expressly covenants that, number 1, the creditor is neither a surety nor an accommodation party. See Uniform Commercial Code 3-419 for the debtor. And number 2, the debtor holds harmless and indemnifies the creditor, you, from and against any and all claims, legal actions, orders, warrants, judgments, demands, liabilities, losses, depositions, summonses, lawsuits, costs, fines, liens, levies, penalties, damages, interest, and expenses, both issued in and associated with the debtor's trade name. This issue is extremely profound when one realizes that a man or woman in jail awaiting arraignment, that is to say, a legal event where the defendant enters a plea before the magistrate, is not the actual defendant, but the surety for the defendant. Through more legal trickery, the unwary and unwitting surety is duped into unconscionably identifying him or herself as the defendant when addressed by the magistrate as such, and thereby voluntarily and magically becomes the defendant from that point forward. In this type of exchange, the trade name, the actual defendant, is legally and technically a dummy and serves as the legal object, at least on paper, until the surety associated therewith can be suckered into taking its place. The hold harmless and indemnity agreement is attached with the security agreement described below and made fully part thereof by inclusion in the filing process. A certified copy of a filed UCC financing statement referencing a security agreement and hold harmless and indemnity agreement as set forth in this manual constitutes documentary evidence that the all-caps party named in any indictment, warrant, etc., and not the flesh and blood man or woman being held in captivity, but rather the artificial trade name, a fact of enormous legal significance, considering the techniques used by the judicial system in attracting new customers, generating repeat business, and marketing their services. Next section, the security agreement. Creation of a security interest. Importance of the common law. A security agreement is a consensual agreement whereby a debtor transfers a security interest in collateral in exchange for valuable consideration, and is defined as an agreement that creates or provides for the security interest. This is from Uniform Commercial Code 9-102A73. A security interest is an interest in property that secures payment and performance of an obligation. That's from Uniform Commercial Code 1-10237, and is the Uniform Commercial Code equivalent of a statutory lien, that is to say, a security interest in prejudicial and non-judicial, whereas the private agreement lays out the terms of the commercial agreement between the two parties and is authenticated, meaning signed. See UCC 1-10239 by each agreement concerns only the debtor's pledge of property, the collateral, and accordingly need only be authenticated by the debtor. There is nothing preventing the secured party from signing as well, as is recommended herein. Following execution of the security agreement, and the creditor is known as the secured party, because he has the benefit of a security interest in the property of the debtor. That is to say, he is secured in the event that the debtor does not make payment or perform as agreed. A secured party is a party in whose favor a security interest is created and provided for under a security agreement. See Uniform Commercial Code 9-102A72. When the security interest is said to attach, generally the security interest attaches and becomes enforceable against the collateral the moment the following three requirements are satisfied. Number one, there is an adequate security agreement between the parties describing the collateral. Number two, the secured party or creditor gives value of some kind. And number three, the debtor has rights or ownership in the collateral power to transfer rights in the collateral. See UCC 9-203B. There is, however, two types of property for which attachment of the security interest can occur only in a certain way other than filing, meaning that mere description of the collateral in the security agreement is not adequate. Let's read this part real quick. Value. Because of the contemporary de facto monetary system, which functions in a mirror image of reality via debt instruments, that is to say, Federal Reserve notes, that carry an inherent liability, that is, interest and income tax, rather than lawful money, gold and silver coin, that carries no such liability. The UCC definition of value, a most significant term in the UCC, is 180 degrees out from one found in conventional dictionaries. The bearing of this term on the UCC matters is addressed in the practical portion of this manual. Okay, next section. Types of personal property and collateral. There are two broad types of personal property classifications. These are tangible and intangible. Tangible property is categorized as goods, which means all things that are movable when security interest attaches, and includes fixtures, goods that are attached with real property. Some standing timber, unborn animals, crops, manufactured homes, and computer programs embedded in goods so that the software is considered part of the goods. Okay, see UCC 9-102A44. All goods are subcategorized at UCC 9-102A based on their use in the hands of the debtor into one of the following types. Number 1, consumer goods. 2, farming products. Number 3, inventory. And 4, equipment. Intangible personal property, on the other hand, is classified by its characteristics rather than how the debtor uses it, and consists of the following subcategories. Number 1, money. Number 2, investment property. Number 3, commercial tort claims. Number 4, letters of credit. Number 5, letter of credit rights. Number 6, chattel paper. Number 7, instruments. Number 8, deposit accounts. Number 9, accounts. Number 10, documents. And number 11, general intangibles. There are many more subclassifications of personal property, but all fall within one of the 15 categories of tangible and intangible property. Fortunately, the intricate distinctions of and between all the different kinds of personal property are less significant for our needs than they are for those of Big Brother's henchmen. We are merely bolstering our own position for maintaining commercial integrity. Big Brother's operatives are out there playing the game of swindling people's wealth while attempting to avoid general detection as being engaged in such activity. Remember, the substitute money Federal Reserve note system is designed expressly for generating defaults and bankruptcies and channeling all private wealth into the hands of the owners of the governments. That is why it is so important that the money power have encrypted codes for keeping people in the dark about the law, remedy, and recourse, and blackmail politicians in their pockets for passing draconian totalitarian legislation to crush dissenters, thwart popular movements, and establish the global plantation. Perfecting, legally establishing the security interest. Okay, next section. Perfection of the security interest after the security interest has attached is usually accomplished by the filing of a record known as the UCC financing statement. In the UCC filing office, located in each state, District of Columbia, and most other territories of the jurisdiction where the debtor is located, considered a resident. Okay. Perfection of the security interest by filing is available for most types of collateral and is discussed further below. However, a few types of collateral require that the security interest is perfected by a method other than filing a UCC filing office. Okay, next section. Where a means other than filing is required for perfection. A secured party can perfect a security instrument in deposit accounts, so demand, time, savings, and passbook accounts maintained within a bank. Electronic chattel paper, investment property, and letter of credit rights only by control, UCC 9-314. A security interest in certificated securities in registered form can be perfected only by delivery into the possession of the secured party, and that's UCC 8-301. In the two foregoing methods of perfection, the security interest both attaches and is considered perfected upon control and delivery, respectively, with no filing requirement, UCC 9-203b2. Also, the filing of a financing statement against property covered under any certificate of title statute, as well as any other non-UCC central filing statute, is neither necessary nor effective for perfecting the security interest. See UCC 9-311. The certificate of title statutes, for example, provide for perfection of the security interest directly on the face of the certificate, where the secured party is called lien holder, and cover such things as automobiles, trailers, mobile homes, boats, farm tractors, and the like. Other federal statutes cover items such as aircraft, ships, trademarks, copyrights, and the patents. So these are common law trademarks, and copyrights are not governed by statute. And the filing of a financing statement is likewise ineffective for perfecting the security interest. The redemptor is in a unique position to establish legal control of these types of property, in that he can form another contract with the debtor, as to say, like a storage contract, that must be satisfied before the lien holder can legally take possession of or sell the property discussed in the practical portion of this manual. Through the filing of a financing statement will perfect the security interest in all other subcategories of collateral. The code also allows for perfection of the security interest by simple possession of the following types of collateral: negotiable documents, goods, instruments, money, tangible chattel paper, and the certificated securities. See UCC 9-313. For this reason, the sample security agreement contained in this volume contains a statement wherein the debtor, as the trade name, acknowledges having delivered all such property into the possession of the secured party, thus covering these particular types of collateral by both filing and possession. The power of the common law, next section. Perfection by possession is a species of common law lien, so i.e. non-statutory, and is effected with a simple statement at the top of the security agreement, whereby the debtor acknowledges delivery of all such property, in which a security interest can be perfected by possession into the hands of the secured party, cited in previous paragraphs. A common law lien is a species of lien defined as one known to or granted by the common law, as distinguished from statutory, equitable, and maritime liens. It is a right extended to a person to retain that which is in his possession belonging to another, until the demand or charge of the person in possession is paid or satisfied. That's from Black's 4th edition. Thus, you have a non-statutory, non-judicial, common law origin of your claim of right of possession of the negotiable documents, goods, instruments, money, tangible chattel paper, and certificated securities associated with your strawman debtor's trade name. You have a common law right for retaining possession of all such property until the obligation is satisfied, that is to say, paid off by the debtor, your trade name strawman. Unless and until the obligation is satisfied in full, neither the strawman nor anyone else may lawfully remove a single piece of any of this property, that is to say, the collateral, that has been delivered into the secured party's possession. Let's look at some definitions. For a complete list of exceptions where filing is not required for the perfecting the security interest, see UCC 9-310B. Okay, a lien, a qualified right of property which a creditor has in or over specific property of his debtor, a security for the debt or charge or the performance of some act. Black's First Edition. All right, here we go. The common law, see glossary, is ancient and immutable, established by usage and custom since before recorded history. As strange as it may seem, the common law is still in full force and effect today. People just don't know it because they have been conned into believing it doesn't exist, courtesy of the Federal Reserve note currency monopoly scam and cabal. And unwittingly consent, surrender privacy, grant jurisdiction, with virtually every single advance made against them by government and legal commercial predators. In fact, our impossibly complex legal judicial system and its billions of pages of codified law, including the UCC, have been developed over the last millennia by the creditors and money changers for the express purpose of circumventing the protections afforded debtors by the common law through lexical trickery, deceit, and obfuscation. The UCC is the culmination of these efforts. However, despite the universal power of the Uniform Commercial Code, it is still junior in the face of the common law, as attested by the excerpt from one of the world's most respected authorities on the UCC, Anderson on the Uniform Commercial Code, 1981. Here we go. In the UCC, Section 1, 103(6), Common Law. The Code is complementary to the common law, which remains in force except where displaced by the Code. In attempting to codify a large body of law, it is almost impossible to anticipate all the factual situations that may arise, and it is for this reason that the courts have adopted the principle of statutory construction, that a statute will not be construed so as to overrule a principle of established common law, unless it is made plain by the act that such a change in the established law is intended. A statute should be construed in harmony with the common law unless there is a clear legislative intent to abrogate the common law. Courts should be hesitant to improvise new remedies outside the already intricate scheme of Articles 3 and 4. However, this new cause of action would not interfere with the scheme but extend its principles to the situation not specifically foreseen by the drafters. The Code cannot be read to preclude a common law action, whereas any item of property that is registered in a public registration scheme, i.e. with a government agency, should be specifically identified in the security agreement. A description of all other personal, real property is sufficient whether or not it is specific, if it reasonably identifies what is described, with a few minor exceptions, UCC 9-108. A properly done security agreement is vital for maintaining fiscal integrity, i.e. maintaining control of every single piece of property under the sun, moon, and stars that is considered private property of the trade name. Remember, the entire artificial person insolvent industrial community, functioning as it does solely on debt and liability instruments, Federal Reserve notes, is incapable of establishing accounts and doing business with solvent sovereign creditors. Only bankrupt subject debtors, such as your all caps trade name and of course the surety the shadow sovereign and his inferior degraded status associated therewith. The same security agreement provided in the practical portion of this manual between John Henry Doe and all caps John Henry Doe is certainly many hundreds, if not thousands, of man-hours in the making. Big Brother's legal experts will not be pleased with the soundness of this document. Full realization of its integrity and value will come only with earnest study unless, of course, one simply begins using it as needed and observes the response from the legal professionals that are confronted with it. Alright, next section, the UCC financing statement, perfecting legally establishing the security interest by filing. Besides perfecting by control, so perfecting is legally establishing, besides perfecting by control, delivery, and possession as described above, the secured party can perfect the security agreement or the security interest. So the secured party can perfect the security interest in most types of collateral by filing. The UCC filing office is a public venue for the registration of notice of private contracts. Since the only legal tender currency in America is the private script of the Federal Reserve, all exchange of this so-called, quotes, money, unquotes, has private implications. Hence the advent of the prejudicial and non-judicial, i.e. private, UCC in 1954 and the UCC filing office, which keeps track of the ever-increasing stream of private contracts registered therein by those in the know, wherein Federal Reserve notes comprise the valuable consideration between the contracting parties. UCC filing offices provide a central forum where a creditor or secured party can receive official governmental acknowledgement of the private contract between himself and the debtor, as well as establish seniority over other creditors based on date and time of filing. The foundational filing document is a simple form known as the UCC financing statement, formerly called a UCC-1 financing statement before July 1st, 2001, containing number 1, the name of the debtor, number 2, the name of the secured party, and number 3, a sufficient indication of the property pledged by the debtor as collateral in the transaction. See UCC 9-502A. The financing statement only puts third parties on notice of the secured party's perfected security interest in the debtor's collateral. The security agreement is what creates the security interest and must reasonably identify the collateral described, whereas the financing statement can be general in its description of the collateral. See UCC 9-504-2. The security agreement must meet certain requirements. See UCC 9-108, but the collateral indicated in the financing statement must jibe or match up with the collateral described in the security agreement for the effectiveness of either in securing the collateral, i.e. the financing statement and the security agreement are complementary components. Neither is effective without the other. There is no requirement that a copy of the security agreement be included with the filing of the UCC financing statement, only a sufficient indication of the collateral covered. See UCC 9-502A3. The only requirement is that the security agreement be authenticated, i.e. signed by the debtor. See UCC 9-203B3A. Next section, public filing versus privacy. When a secured party voluntarily makes public the intimate details of the private security agreement, as I say, between secured party and debtor, by including it on the filing of the financing statement in the UCC filing office, where anyone can easily obtain the information simply by paying for it, he or she forgoes any privacy protections afforded under common law and the Fourth Article of Amendment of the Constitution. There is no compulsion for making public the private contractual relationship between the secured party and the debtor. Therefore, it is recommended that the security agreement be only accurately identified in the UCC financing statement and not filed along with it. Let's read this definition. The financing statement must cover the collateral described in the security agreement for valid perfection of the security interest by filing. If the security agreement does not describe the collateral indicated in the financing statement, perfection cannot not occur via filing because no security interest ever attached the collateral in question. Here's a real-life example from December 31st, 2001 article in a obituary section of the Los Angeles Times, page B11, on the late Ian Hamilton, revealing the liabilities that come with voluntarily placing private information in the public record. Hamilton had created notoriety for himself by writing an unauthorized biography on J.D. Salinger, called J.D. Salinger, A Writing Life. Salinger opposed publication of the book for several reasons, but the only line of attack available was in suing for Hamilton's use of Salinger's common law copyrighted material for commercial gain. That is to say, insertion of about 70 of Salinger's private letters written to publishers, editors, and friends between 1939 and 1962 in the book. Here's a portion of the article. The biographer and publisher won the first round when a New York federal judge ruled that Hamilton's book cannot be dismissed as an act of commercial voyeurism or snooping into the private being's private life for commercial gain. It is a serious, well-researched history of a man who, through his own literary accomplishments, has become a figure of enormous public interest. Hamilton's use of Salinger's copyrighted material is minimal and insubstantial. The judge continued in his 33-page decision, which was seen as a victory for the First Amendment and does not exploit or appropriate the literary value of Salinger's letters. But in early 1987, a federal appellate judge overturned that decision and banned publication of the letters. The U.S. Supreme Court upheld the ban. Biography revised after court feud. Both writers, as it turned out, won some and lost some. Salinger won his goal to keep his letters out of the biography, but thanks to a civil suit, the letters became part of the public record, more accessible than ever. Hamilton recouped, excising the letters, but revising the biography to include insights gleaned from the bitter court feud. He published In Search of J.D. Salinger in 1988. Salinger's private common law copyrighted material was just that, until, that is, Salinger voluntarily made it part of the public record by entering it into the lawsuit. Salinger successfully stopped publication of Hamilton's original book because it contained the letters, Salinger's common law copyright property, but officially placed it into the public domain, the very information he wished kept confidential. Interesting. Though the actual letters themselves were not used in Hamilton's second book, all the information contained within the letters was now in the public realm, fully accessible and available for anyone's use, including Hamilton's. Okay, here's some noteworthy points. Number 1, a common law copyright is a supreme claim. And number 2, voluntary surrender of information is a waiver of privacy and security protections afforded by Article 4 of the Constitution. Interesting. However, there are many more ways of surrendering one's privacy and sovereignty than anything as extreme as the court case, and, like J.D. Salinger, nearly every sovereign American man and woman repeatedly and inadvertently does this throughout his or her life on a regular basis. Any degree of agreement with the advances of an aggressor constitutes acceptance of an offer and forms a contract. Something as innocent as leaving the front door of your house, and likewise the door of your car, unlocked admits and grants jurisdiction. Even responding with a policeman's demand for communication through a locked door of your house can form a contract and justify destroying the door and coming in anyway, euphemistically called dynamic entry. Responding with any request for information of any kind, no matter how slight, from a code enforcement agent officer forms an unconscionable contract that can worsen very quickly. By consensually participating in the seemingly most harmless of conversations with any type of investigator. Okay. Regular basis. The same security agreement in this handbook is designed for keeping private as much information as possible and need not be publicly filed along with the financing statement, merely authenticated, signed by the debtor. This security agreement is also believed legally impregnable by third parties, and the redemptor who understands and knows the proper use of this document can begin to enjoy the profound benefits associated with its use. Financing a statement is defined as this: a record or records composed of an initial financing statement and any file recorded or any filed record relating to the initial financing statement. UCC 9-102A39. Modifications, changes, and adjustments of the original financing statement are implemented with what is called a UCC Financing Statement Addendum, formerly called a UCC 3 before July 1st, 2001. In most jurisdictions, and a UCC 2 in others, as revealed in the definition of financing statement above, any subsequent related UCC financing statement amendment filed qualifies as any filed record relating to the initial financing statement. That is to say, any amendment is absorbed by and automatically becomes part of the original financing statement. Alright, let's recap. Publishing a notice of common law copyright, the strawman's trade name or trademark, establishes common law control over the trade name. That is to say, the debtor and the relationship. Filing at the county records office further solidifies the ownership of the common law copyright, the foundational contractual document between debtor and creditor is called the private agreement, and evidences the commercial agreement and the rights and duties and between the parties in the mutual beneficial consensual commercial transaction. The debtor indemnifies the creditor in the hold harmless and indemnity agreement, and the legal distinction between the two is made clear. The creditor establishes a bona fide claim called a security interest, equivalent of a lien, in the property pledged by the debtor as a collateral by giving valuable consideration. The security agreement is a document authenticated minimally by the debtor and contains a description of the collateral that secures the indebtedness in favor of the creditor, who is now called the secured party. When the debtor authenticates the security agreement, the security interest attaches and becomes enforceable, except for a few types of collateral when the secured party files a UCC financing statement and references an existing authenticated security agreement therein. The secured party's security interest in the collateral is considered perfected, that is to say, legally established. Generally, the earlier date and time of filing determines priority of the debtor's collateral between the competing creditors. Any desired changes in a financing statement are effected using a UCC financing statement amendment, which becomes part of the original financing statement upon filing. So, in the next section, why revise Article 9? As near as is indiscernible, the primary aim of the new Article 9, which deals with secured transactions, is the establishment of wholesale methods for foreclosing on the defaulting debtor's property, that is the collateral, without using the courts, that is to say, the high-speed transfer of wealth, yours, into the hands of the money power and its minions. Even the UCC itself, it appears, has been formulated as an entirely new system for circumventing the ancient protections in a debtor's property, collateral and transaction, afforded by possession under the common law. The UCC and now revised Article 9 have introduced sophisticated methods for obtaining the debtor's consent and agreement concerning depositions of the collateral in event of default at the time of contract is formed. This means fewer headaches for your friendly creditor-lender banks in seizing the property of victim debtors as the defaults roll in, an inexorable eventuality under the current financial scheme, non-substance debt currency. In accordance with revised Article 9, contemporary commercial contracts, mortgages, loan agreements, and credit applications, etc., have also been cleverly formulated for obtaining the borrower's consent for converting all the debtors after execution of the contract property into collateral, but without the borrower's awareness of the fact, and then foreclosing on and seizing such property upon default without any need for a court order. People who enter into such contracts without a security agreement against their trade name firmly in place have no protection over property acquired after entering into a loan agreement should they default. And remember, the monetary system is expressly designed to create defaults in loan transactions so the owners of the system can legally expropriate the victim's property without arousing suspicion of foul play. A major character flaw of modern Americans in general, that the entire UCC is designed to prey upon, is their propensity for accepting loans of credit, that is to say, something for nothing, and living beyond their means. The take of the credit lending vampires would be significantly diminished if people stopped asking for handouts or borrowing and using credit, and began surviving strictly through their own efforts and living within their means. This might mean a contemporary reduction in standard of living, but at least one would be on solid ground financially, living within reality and free of the inherent fear of default, foreclosure, and financial ruin that is part and parcel with keeping up with the Joneses. The system cannot easily dominate over those who do not borrow. Some wise words from William Shakespeare's Hamlet, appearing in the front of this book, are requoted here. Neither a borrower nor lender be, for a loan oft loses both itself and friend, and borrowing dulls the edge of husbandry. Let's read this little part real quick. Possession is 9/10 of the law. 95. Except revisions in Article 3, that is negotiable instruments, and Article 4, bank deposits and collections before 2010. Okay, 96. Defaults and bankruptcies are a mathematical certainty in a credit money system. Where money is loaned into circulation, only the principal amount is created. Any payments of interest must come from the amount loaned out, the principal. It is easily seen that paying off both principal and interest is a mathematical impossibility because the total money in circulation consists only of the principal amount. That is, a loan of 10 credit unions with an annual interest of 10% requires a payment after 1 year of 11 credit unions. But there are only 10 credit units in existence. If interest payments were made for 10 consecutive years, payments totaling 10 credit unions, the money supply would vanish, but the principal amount would still be owed. The only way of satisfying the requirement of making interest payments yet maintaining an adequate supply of currency in circulation is through borrowing, an even worsening debt scenario. So the national debt is owed to the Federal Reserve Bank. Okay. Next section, benefiting from the UCC and revised Article 9. The complexity of today's multifaceted judicial, taxation, financial, and political systems, and the breadth and depth of collusion and complicity within and amongst their ranks cannot be exaggerated. Management personnel in each, beginning at the bottom and going all the way up, know that continuing financial gain is predicated solely on the establishment of commercial accounts in people's mirror image, artificial person, all capital trade name, and the execution of billing, collection, and foreclosure procedures against said name. Experience with actors at all levels in each of the above sectors has revealed that all are familiar with the nature of the game, and the higher the level, the more knowledgeable about ensuring its perpetuation. Operatives within the system, each an integral cog in the revenue extortion conveyor belt, are generally afforded virtual, if not complete, immunity by the powers that be for crimes committed in the line of duty. Judges could not operate without immunity. In case you do not know it already, the only time an out-of-control bureaucrat will reform and change his or her ways is when faced with the possibility of personal liability, damages, and losses. Heretofore, there have been a few solutions for bringing about such results. The essential difference between those who work in modern government and those who work in the private sector is that the latter must, for the sake of survival, produce a valuable product, deliver a valuable service that someone else will voluntarily exchange money and something of value. Generally, the government and other code enforcement types, so the IRS for one, is not part of the government, see the glossary, are insulated and exempted from this otherwise most basic requirement for survival in today's society, living instead off wealth extorted from others who actually do the work and produce articles and services of value. Modern governments using valueless Federal Reserve, international money, or monetary fund script as the exclusive medium of exchange are sanctimoniously self-protecting, self-aggrandizing, parasitic, bankrupt commercial front operation for their shyster creditor masters. Offered herein are simple procedures for using the same techniques against those who would deceitfully subjugate you and enrich themselves courtesy of your labor and misplaced trust. The self-preservation process depends on your awareness of, number one, your true name and trade name as legal entity, artificial person, separate and distinct from you, and number two, your common law right to be compensated for the use of your private property, and the method afforded by the UCC for enforcing this right. A reminder of how things can actually be if enough people stop consenting with tyranny in any form. We hold these truths to be self-evident, that all men are created equal, that they are endowed by the Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights governments are instituted among men, deriving their just powers from the consent of the governed, that whenever any form of government becomes destructive to these ends, it is the right of the people to alter or to abolish it, and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. This is the Declaration of Independence, 1776. Government needs to get the consent of the governed. All right, coming up next is Section 2, The Truth About Esquires, Undressing the U.S. Judicial System.